And then the last paragraph says the statements are intended to expose me to hatred, contempt, ridicule, and to diminish the esteem in which I'm held by the people of the Republic of South Africa. Of course, the response to this complaint identified that they were, in the pleading, there was a confusion between what would rightly belong to defamation law and what might rightly belong to the Equality Proceedings, Equality Act. And that, in the directions meeting that followed on the 29th of May 2019, resulted in a discussion between the parties and my Lord Presiding in relation to the further conduct of the matter. And it was made clear then that the applicant might wish to clarify precisely what statements he pursues, on what basis, and the respondent would be afforded an opportunity to respond to that case, either that way, by filing a further affidavit, which would take the form of a replying affidavit, alternatively that he would withdraw and resubmit a fresh complaint. But it was envisaged in that discussion and agreement that, unlike in the normal procedure under Rule 6, where once there has been an answering affidavit and there is a reply, the pleadings are closed, and if there is to be a further affidavit, the leave of the court was required. Here, it was made clear that the clarification that would be provided by the applicant would then be responded to in full, and that response can further be responded to by the applicant. So the kind of prejudice that would generally arise where a replying affidavit raises new matter, for example, assuming there's new matter here, raises new matter, would not and doesn't arise in this case. And in fact, shortly I will show my Lord that when Mr. Malema filed his response, he never complained about any prejudice because a replying affidavit has raised any new matter. He was content, in line with the agreement, to simply answer to that complaint as clarified by the Minister. Now, this procedure is of course permissible because, as Manon has said, this court is a special animal. And Justice Nafsa said in today's language one would call it a special purpose vehicle. And he does that at paragraph 57 of Manon, which we referred to in our heads. And preceding that, he discusses the court's powers to issue directions in relation to the filing of affidavits and the hearing of evidence. And he does that, my Lord, at page, from paragraph 37, 38 to 39. It might be useful just to refer to the paragraph 37, where he says the procedures for regulating proceedings are to be found in the Act, read with the regulations and the rules of this court. And he says in relation to the regulation at paragraph 37, the last sentence, Regulation 10.1 states that the inquiry must be conducted in an expeditious and informal manner, which facilitates and promotes participation by the parties. Regulation 10.3 provides that the proceedings should, where possible and appropriate, be conducted in an environment conducive to participation by the parties. And then 38, which is more directly relevant to my submission, at a directions hearing, the presiding officer must give directions in respect of the conduct of the proceedings as he or she deems fit. After hearing the parties, the presiding officer may make an order in respect of a range of issues, including discovery, interrogatories, admissions, the filing of disputes, the rejoinder of parties, amicus curiae interventions, the filing of affidavits, the giving of further particulars, the time and place of future hearings, procedures to be followed in respect of current matters, and the giving of evidence at the hearing, including whether evidence of witnesses to be given orally or by affidavit or both. And it's given also latitude to deviate from those procedures, provided it's in the interest of justice to do so. So following those procedures, followed, which the Act and the regulations and the rules conferred to the court regulated their procedure and made it clear that the further reply, in effect, takes the form of a clarificatory affidavit where it makes clear that the applicant proceeds on this basis and in respect of this case only. Now, in the replying affidavit was filed, and that my Lord will find at page 295. in volume 4. And
so I have it?
yes. At page 295, it starts off by repeating what I just submitted, Manu, by summarizing the directions hearing, the timelines that we allowed for the filing of further affidavits, and says this is that affidavit that was contemplated in that directions hearing. And then it says, paragraph 9, I have decided to pursue my complaint against only against Mr. Julius Malema for his contravention of sections 10 and 12 of the Promotion of Equality and Prevention of Unfair Discrimination Act of 2000. Malema contravened sections 10 and 12 of the Act on 20 November 2018 in public remarks made in Cape Town, Johannesburg, outside of the venue of the Commission of Inquiry into allegations of state capture, corruption, and fraud in the public sector, including organs of state. And he says, I had appeared before the State Capture Commission on that day to testify. And he says, then he quotes the statement made by Mr. Malema and identifying the particular parts of those statements which he complains about. He says, Mr. Malema made several statements about me that day that contravened sections 10 and 12 of the Act. These statements included, and I made a read them for the record, my Lord. Our attack on Pravin Gordhan is an attack on white monopoly capital because Pravin is a dog of white monopoly capital. We must keep the dog until the owner comes out, and once the owner comes out, we must deal decisively with the owner. Pravin is a cabal that belongs to the UDF and destroyed all good African comrades. He's no good, this guy. He has destroyed Peter Mokaba, he has destroyed Winnie Mandela, he has destroyed everyone else that stood for the truth against the apartheid regime. His shenanigans are not new. Pravin has gone into all SOEs and removed all black excellence because he hates Africans. He doesn't like Africans. Any African that speaks back to Pravin threatens those people. Once you take a decision to go after Pravin, you must be ready. If you're not ready, don't come to the EFF. We've now taken a decision to fight Pravin, and therefore you must know Pravin is going to fight dirty. There will be casualties. There can even be a loss of life. If you're not ready for that, stand aside. I'm not scared. I'm ready. I'm prepared to confront them one by one. And then the applicant says, this words contravene sections 10 and 12 of the Act in that day. 13.1, single me out on the basis of my Indian race, ethnic or social origin, color, conscience, or culture. Portray me as a dog of white monopoly capital who must be hit. Claim that I destroyed individuals who stood for truth against the apartheid regime. Claim that I hate Africans. Claim that I threaten African people. Indicate that the attack on me will lead to casualties and even a loss of life. And then demonstrate, then goes to the requirements, my Lord, of the Equality Act. And then the relief that is sought is repeated from the founding affidavit. And then Mr. Malema responds to that in line with the directives at page 301. And he says, he tells us that at 302, he tells us that he's filing this affidavit in line with the court's directives regarding the further conduct of this matter. He says, I'm advised that at the pre-trial conference convened by His Lordship, the Honourable Mr. Justice Sutherland, various timelines for the further conduct of this matter were agreed by the parties and approved by Sutherland J. In particular, the applicant was given an opportunity to either withdraw the complaint as pleaded and issue same de novo, or persist with the application and file a replying affidavit wherein the applicant could address the issues raised by the respondents in the answering affidavits. You recall, my Lord, some of those were legal objections about why this is not an Equality Act matter. And then depending on the applicant's choice, the respondents were then given an opportunity to either file a new answering affidavit. They understand this is a new answering affidavit, my Lord. It's not a further affidavit as one would file under Rule 6 following leave granted by a court. In respect of the new application, or file a further affidavit in respect of the applicant's replying affidavit. My Lord, I confused the two, but it's a further affidavit if he chooses to simply clarify. This was to be done by 8 July 2019, and on 7 June, the applicant's attorney of record advised the parties and the court of the application. The applicant will not be withdrawing the application, and that he would be proceeding to file a replying affidavit, Then the replying affidavit was filed on 24 June 2019. Then he says this affidavit is the further affidavit referred to above. And then he says what is the status of Mr. Shivambu's affidavit. Malod will recall that in his answering affidavit, Mr. Malema incorporates wholas bolas the affidavit of Mr. Shivambu and says he associates himself with what is said in that affidavit. In relation also to explanations for why the words used were used in the context. Then in relation to status, he says the replying affidavit, what is noted in the replying affidavit, what is most notable is that the applicant has withdrawn his complaint against the second respondent. It has also reduced to writing the particular statements of mind that it objects to, in respect of which it pursues its original relief, saying that now only does so against it. So he understands this case is not, it's the same case, just continuing, clarify. Then he says, the applicant is of course entitled to withdraw the application against the second respondent. However, the applicant's election in no way serves to limit the relevance of nor my reliance on Mr. Shivambu's affidavit. To that end, I point out that Mr. Shivambu's affidavit was properly set of record. The applicant's election does nothing to change that. It is competent for this court to have regard to saying. Mr. Shivambu's affidavit was specifically incorporated into my answering affidavit to the extent that Mr. Shivambu's affidavit addressed various issues which I make common cause with in respect of their relevance to my defenses in this proceedings. Mr. Shivambu's affidavit thus continues to serve as an additional supporting affidavit that I am entitled to rely on. The applicant's withdrawal of the complaint against Mr. Shivambu does nothing to affect that. Then he persists with the defenses. So he's saying to your clarified complaint, my answer remains the same. So, Malo, there is nothing prejudicial here, and no prejudice is suggested in this affidavit, no objection is suggested in this affidavit. The objection taken with respect to the heads of argument is taken so opportunistically. Even there is no prejudice that is alleged, in effect, because the case was always there. And we also submit to the court that even the rule regarding the raising of new matter in reply is not inflexible. There are circumstances in which courts will allow new matter to remain, especially in this case where we are responding to legal issues that are raised in the answering affidavit of Mr. Malema incorporating Mr. Shivambu's affidavit. So we submit, Malo, that when the court looks at what is the case for the applicant, the court must look at both affidavits. And the answer to those both affidavits is to be found in Mr. Malema's affidavit incorporating Mr. Shivambu's affidavit. And that's the basis on which we submit the matter must be adjudicated. Then if I may, I'll move to the next point, which is the interpretation of section 10 and 12. My Lord is aware that the proper interpretation of section 10 has received judicial treatment in this court and in the SCA, and there is a pending appeal to the Constitutional Court in the Masuki judgment, and there's a pending judgment in Kwelane, which was argued in August. So what was indicated at the directions meeting, where the court rightly raised the issue about the potential stay of the proceedings pending the outcome in Masuki, was that we are, for the applicant, prepared to argue it on the narrow construction which would make the section consistent with section 16.2 of the Constitution. In other words, the approach adopted in Kumalo by this court, that one must read the subsections in section 10 conjunctively and not disjunctively, and that there must be incitement shown in the utterances that are complained about. And that is in paragraph 82 of the Kumalo judgment. What was slightly unclear from the judgment in Kumalo was whether in relation to section 10 and the subsections, the conjunctive reading relates only to the subsections A, B, or C, and C, or whether it operates even within them, because my Lord will know that in B there are two parts which are combined by the word or, and in C they are also combined by the word or. But our submission is that it wouldn't really matter in relation to consistency, as long as incitement has to be shown, because that would still be consistent with section 16.2. So if one shows that there is incitement for harm, it doesn't matter whether whether internally there must be a conjunction or must be, the two parts must be read disjunctively, because that would still, we submit, be consistent with section 16.2, because that section, my lord, says that in C, that the right in subsection 1 does not extend to advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. So the incitement is joined to all of those. So as long as incitement is required, we would submit, my lord, that it doesn't really matter what one does internally to the subsections. And as we understand Masuku, the court also decided on that basis that if the statements complained about fall within 16.2, then that there is a breach, whichever way one reads section 10. So we are happy to present our case on that basis. And we also submit that what Moyo adds to the debate, if our hunch is correct about what the court required us to think about, is that what it really says is it's permissible to read the subsections consistently with section 16.2, provided the court is satisfied that the wording of the section is reasonably capable of that interpretation. In the Moyo case, it would seem that the departure for the majority in the SCA was, well, it's difficult to work with that section, but one can start from the common law definition of intimidation, or the general definition of intimidation, and in a sense impose it on that section, and then say there must be an imminent incitement of imminent violence or harm, I can't recall which is which, but the important thing is the importation of a whole concept into the section. And the court said, but that is legislative, is crossing the line from interpretation and legislative. We would submit, my lord, that there should be comfort for this court in light of the approach in Masuku, although we know it's pending appeal to the Constitutional Court, that court was content to approach the matter on the basis of 16.2. And we think that is probably appropriate because, first, the Equality Act says it must be consistent with section 16. And also, in this case, the defense raised implicates section 16. So if the court went back and said the starting point is section 16, if there's consent that the section 10 travels beyond section 16, then you can stop at 16.2. Especially that there is no constitutional challenge, so we can't save section 10. So it ends at an interpretation level. We would submit that the court can take comfort from Masuku and approach it on that basis. And then we would have to lie on the bet that we make, that we accept the interpretation in Kuma. And we submit that even on that interpretation, we should be able to demonstrate to the court that on the test in Kuma, there is incitement here. There is a prohibited ground and there is incitement. So I get, my lord, to the prohibited ground, and we think, my lord, with respect to that this is the key issue for the court to determine. And in that way, we associate with the approach of our learned friends, both for the amicus and the respondent, because they focused first on that issue. So in the criticism about, but the case made out in reply, is that in the founding there is no prohibited ground identified. I showed that there is race, and that is expanded upon in the reply affidavit. But the starting point is the correct one we submit, and we submit that once the court is with us on the presence of a prohibited ground, it would be very difficult not to find for us for the balance of the requirements. Now, so both the respondent and the amicus say that there is not reference to a prohibited ground in the impugned statement. And we submit that this calls for an interpretation of the impugned statement. It's not a matter of just looking at the impugned statement and say, I can't see race, I can't see conscience, I can't see gender or all the other prohibited grounds, therefore it's not there. As Masuku tells us, at paragraph 26 and 27 is a matter of interpretation, and there may be an implied meaning from the statement which clearly shows that there is a prohibited ground, and that is arrived at by looking at the statement in the context in which it was made. And we would submit to the court that although our learned friend for the respondents say that plus-one evidence operates in their favor, in fact, you don't even get to plus-one evidence because the material that form the context is common cause. The place and the time and the event at which the statement was made is common cause. You will see also that some of the contextual elements which go to the meaning of certain of the words used is also common cause. The differences may be as foreshadowed in the strikeout applications, whether some of the reports relied on are genuine, real, hearsay, relevant, and so forth. I will identify the key elements, and my Lord will see that these are common cause, and the court will be able to place meaning on the statement based on those. So first, of course, that the interpretation, we follow the usual approach, which is established in the menu context, words, purpose, not words in isolation. And Masuku, I refer to paragraph 26. Perhaps just to make it clear that that's what is implied in the judgment is that it says that so at paragraph 26 in Masuku the court looked at whether the offending terms racist, fascist, and friends of Hitler either on their own or within the statement connote religion or ethnicity, so looking for the prohibited ground. The terms may be irrational, offensive, or even insulting, threatening or unsavory words in the statements such as bitter medicine and perpetual suffering are only metaphorical. Even if ethnicity or religion was implied in the block statement, neither the offensive words nor the block statement could be considered advocacy of hatred or incitement of harm for the purposes of section 16(2)(c) of the Constitution, particularly in the context in which they were made. So the context is always important. When you recall, here was a gathering where the statements were spared, in fact, by some of the complainants, people from the complainant group, taunting the speaker as it was. But so the point here is, you could have contextually, there could be an implied meaning which indicates a prohibited ground, and we'll come to that. The second is in paragraph 27 of Masuku, which says these statements also fail to be interpreted within the context of the speech and the circumstances attendant at the place and time they were made. So those are important. Now, as I submit, those are really common cause. The time, place, and event are all common cause. So, what is the context, my Lord, which I've submitted is common cause? First, it's common cause that Mr. Malema was addressing supporters of EFF, of which he tells the court he is the commander-in-chief and president. And this was on 20 November 2018, and outside the office of TISO Blackstar, which is the venue for the Commission of Inquiry into State Capture, at which the applicant, Mr. Gordhan, had given evidence. And he's referred to the passage in the replying affidavit. Now, it's important, my Lord, that it's also common cause that the statements by Mr. Malema followed upon the blog which Mr. Shivambu had published. And that, my Lord, will find, it's quoted in the founding affidavit, and it starts from page 6 of the founding affidavit. So, my Lord will see at the top of the page 6, I refer to the details of Mr. Malema's statement, and you will see it's on 20 November 2018. And towards the fourth paragraph from the foot of the page refers to, the third last paragraph refers to the blog. It says, in a blog by Mr. Floyd Shivambu dated 19 October 2018 titled, Pravin Gordhan runs a cabal and operates a parallel state apparatus in South Africa, which can be accessed on this URL internet link. And quote, PG, as his proteges refer to him, implies a combination of narcissism, self-righteousness, manipulation, and threats to domesticate African comrades and achieve his selfish ends. His overarching and abiding intentions are the protection and empowerment of people primarily of Indian descent. All of this he does under the cover of transformation. Toward this parochial end, he finds a ready ally in the white capitalist establishment. As will be argued, Pravin and his cabal employs political blackmail to slander political opponents and then hold his actions and articulations up as a modular example of political virtue and duty. In an article published in 1917, Lenin warns against political blackmail, which is defined as the extortion of money under threat of exposing certain facts or invented stories which may be disagreeable to the person concerned or under threat of causing him some other unpleasantness. Political blackmail is the threat of exposing or the actual exposure of true but more invented stories with the aim of causing an opponent political damage, of slandering him, of depriving him of the possibility of engaging in political activity, or of making it difficult for him. Then he says this: the cabal was basically an Indian cabal that was put in place to slander the character and standing of African comrades in the MDM, and it was led by Pravin Gordhan. Even when then it goes on, so even when the MDM was confronted with a common enemy, the white settler colonial state, Pravin was keen on sowing divisions within MDM structures, undermine and denigrate the role of mostly African leadership in the mass movement. The essence of Pravin's ideological and political outlook was and remains collaboration with existing capitalist interests and undermining the overall leadership of the movement. One of the distinct features of the cabal under the leadership of Pravin was domestication of African comrades, and this phenomenon continues to define how he relates with African leadership in the ANC up to this day. So he tells the court, my lord, there, and this is repeated in the complaint, that this is not an amorphous cabal. It's not, as Mr. Malema so coyly says, I say coyly in his answering affidavit, says this could be a faction and all of that within the ANC, this is common. No, this cabal here take a particular meaning, and he says so in his complaint, which is published on his blog. And my lord, this is common course with Mr. Shivambu. Recall that Mr. Malema incorporates Mr. Shivambu's affidavit, and I just want to refer, my lord, first to Mr. Malema's affidavit from page 46. So at page 46, at paragraph 112, he says, he talks about, he first isolates the various words. He criticizes the applicant for attempting to take words out of context and then giving meaning and then parachuting them back into the passage. But you'll see, my lord, in his tortuous attempt, we submit, to deal with the meaning of the words he uses, he approaches them in that way. He takes words out and he says what they mean, that word, what it means, which is unhelpful to the court. He says in 112, in the section below, I do not address the underlying reasons for using those particular words, which I shall briefly address further below, but the reasons for which emerge more fully from Mr. Shivambu's affidavit. So if you want to know why Mr. Malema chose to use the word cabal of the UDF, which destroys Africans, you must read Mr. Shivambu. And Mr. Shivambu, and then he says also at page 56, my lord, at page 56, at paragraph 135, he says at the top of that page, in this regard, I asked the court specifically to read Mr. Shivambu's affidavit as being incorporated herein. Mr. Shivambu's affidavit more fully addresses the documents in question, which informs our views of Mr. Gordhan. And then he does that again, my lord, at page 57, at paragraph 143, and more specifically under the UDF cabal. He says, I refer to the contents of Mr. Shivambu's affidavit. In particular, I highlight the fact that it is well known that Mr. Gordhan was implicated in various instances of organizational ill-discipline that included sectionalism within the mass democratic movement. We know that's he's talking about this cabal. And then page 63, at paragraph 167, he says, in addressing Mr.